Hi everybody, welcome to our Back to the Basics series. Here we break down complex legal concepts into bite-sized podcasts. Today we look at the concept of arbitrability.
Arbitrability may seem like a daunting term, but it simply means what disputes can be settled by arbitration instead of a court. Think of it like a bouncer at a club. Some disputes may get in, others don't.
While most commercial disputes can slip past the velvet rope, disputes in some areas like criminal cases or family law get stopped at the door. The bouncer in this case is the law.
Why do these disputes get stopped at the door? It's because they often carry a public interest angle. Now, these disputes usually involve public rights, broader societal concerns, or the rights of a third party. In such cases, it's considered essential that they aren't resolved privately and confidentially through arbitration. The public interest demands transparency and judicial oversight. This is called objective arbitrability or arbitrability rationale materia.
But arbitrability isn't just about what disputes get stopped at the door. It's also about who gets stopped. Some laws prevent disputes involving the state or public entities from being sent to arbitration. This is known as subjective arbitrability or arbitrability rationale personae.
So what sets the rule for our bouncers? Now, different countries have different laws. What is considered as arbitrable in one country may not be considered arbitrable in another. Just like different clubs have their own rules on who can enter, different legal systems have their own criteria on what disputes can be arbitrated.
Think of the test of arbitrability as a vigilant bouncer at a nightclub, thoroughly checking who's allowed to enter. Legal systems similarly have their checklist to decide if a dispute can be settled through arbitration. In India, for instance, three key criteria must be met. Consider these as the bouncer's checklist. First, the dispute must be between specific parties and not a general issue affecting the public. Second, the subject matter of the dispute must fall within the scope of the arbitration agreement. And third, the dispute should have been referred to arbitration to begin with. Now, each of these ensure that only suitable disputes make it through the arbitration door.
Now, you might be curious how our bouncer handles it when different countries have opposing views on arbitrability. Take disputes over oppression and mismanagement, where a minority shareholder feels sidelined by a company's management or the majority shareholder. Now, Singapore law actually permits these disputes to be arbitrated, while the Indian law does not.
This recently became a big issue in the case of Anupam Mittal versus Westbridge, or what is popularly called as the Shadi.com controversy. Singapore courts allowed the arbitration, recognizing that issues of oppression and mismanagement can be arbitrated under the laws. Meanwhile, Indian courts issued an anti-arbitration injunction to stop the arbitration, declaring these issues non-arbitrable under Indian law.
Handling such a dilemma, the principles of conflict of law come into play here. Courts, when faced with an arbitrability question, first determine the applicable law for deciding the arbitrability. Once the applicable law is identified, the court then applies the test of arbitrability under that particular law. But this can still lead to complex situations.
Now, under the New York Conventions, arbitration awards issued in one signatory country are enforceable in other signatory countries. As of now, there are 172 signatory countries to the New York Convention. It is not possible for a court determining arbitrability to consider the law of all of these signatory countries. As a result, an award that is deemed arbitrable under the laws of the country where the arbitration took place, i.e. the seat, may be found unenforceable in other countries.
That's why when you're drafting a contract, it's crucial to think about these potential disputes and where you might want to enforce an award. This foresight could actually prevent future disputes on the dispute resolution process itself. Whether dealing with a club bouncer or a courtroom, knowing the entry rules really helps.
So that wraps up our discussion on arbitrability for today. We hope this breakdown has shed light on why some disputes get the green flag for arbitration while others hit a legal roadblock. Join us next time as we continue to demystify legal concepts in a Back to the Basics series.